Good morning, sir. Are you John Roy?
Yes, ma'am.
And Mr. Stringfellow, will your client waive the formal reading of the indictment?
Yes, ma'am.
Mr. Roy, in cause number 25, DCCR 1365, you're charged with the state jail felony offense of driving while intoxicated with a child under 15, and that's from July 3rd of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily, and because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Stringfellow? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated for 4 years. You would be ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1, Mr. Stringfellow.
Yes, ma'am. No objections.
It's admitted. Is there any evidence that Mr. Roy is not competent? All right, Mr. Roy, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a precedence report.
A couple of things, Judge. The agreement contemplated an interlock device. I don't know if we put that in the paperwork. And another thing, Judge, I don't know if the court would entertain, Mr. Stringfellow and I talked about this, maybe waiving if he is in this case.
Okay, let me, can you send me that paperwork back, Anna, and I'll write, that's your agreement, is that he would have an auto ignition interlock device on any vehicle he drove?
Yes, ma'am.
No history that you
Judge,
can,
the state's file reflects a 1994 operating a vehicle by intoxication. That's out of the state of Louisiana, and a couple of arrests, an arrest for battery in 2008, another arrest for battery in 2019. Other than that, no other criminal history. My understanding is that the defendant is from Louisiana.
Yes, he resides in Louisiana.
okay. So, with everyone's permission first, can I make that right in on that agreed punishment recommendation page, the agreement for the auto ignition interlock device?
No objection.
No objections.
All right. So then what I'm going to do, Mr. Roy, based on Mr. Coleman's representations with regard to any real lack of criminal history, is waive the pre-sentence report. So again, make that finding that you entered that plea freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of the state jail felony offense of driving while intoxicated with a child passenger. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison, but I'm going to probate that, so you're on probation for 4 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That includes having the auto ignition interlock device on any vehicle that you drive. You cannot drive a vehicle unless it has that. You'll talk to probation today here in the courtroom. She'll probably send you over to the probation office at some point. It's important you give them all the information of where you live so that they can work on the proper process of getting your probation transferred over where you are, okay? I'm handing you now the trial court certification. That shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with your attorney. All right? Good luck to you, sir. Make sure you stop and talk to probation. She might be ready for you now. She might have you have a seat and then visit with you. Yes, sir.
He currently has a portable device. Do you think it's possible for him to keep that device instead of installing the permanent machine into his vehicle?
Mr. Coleman, what's the state's position with regard to the portable?
Not necessarily opposed to that, Judge.
Is it required It's not required on the state jail felony for him to have, for me to make a finding on the auto ignition interlock. It's not. Okay, so what I will do is have probation place, if he has the portable, he doesn't have to have the auto ignition. If there's any issues at all with missing portable, if you miss blowing or it's, whatever happens with that, number one, it could be a violation of your probation, or it could require maybe having both or whatever it's gonna take for me to feel like you're safe out there on the road. But keep doing the portable for now. I'll take away that interlock requirement unless there's some issue that comes up that makes me feel like that would be necessary.
Thank you.
All right, yes, sir. So stop and talk to probation. She'll let you know you probably need to have a seat after that for a few minutes. All right,
Thank you, Judge.
thank you, sir. Have a safe. Good morning, sir. You're Bart Thibodeau?
Yes, ma'am.
And Mr. Thibodeau is here in cause number 25 DCCR 0339, charged.
Right here, we're in the early stage of the hearing with 2 charges already in focus. It may sound procedural, but this moment quietly sets the tone for the entire case. What kind of defense strategy do you think is starting to form in review?
Solicitation of prostitution, and 25 DCCR 0755, charged with possession of a controlled substance. And what is the announcement?
Plead not guilty to those counts.
And let's see, when were you, I'm trying to see
January 8th, I believe.
when you were hired. I don't even see it in this
I did a
file.
motion, did I have it? 'Cause I got most of this covered after
No,
some
I'm sure
point.
you did, but otherwise I wouldn't have you on my docket. I just don't see when it was filed.
That 30-day reset is all about discovery, the stage. Where attorneys review evidence and build their game plan, this phase can completely change a case. Would you feel relieved to get more time or nervous about what's coming next?
So what I'll do, Mr. Thibodeau, is reset the cases for about 30 days to give you some time, get with Ms. Malfino. She'll explain the process to get on the portal, to get all the discovery, and then we'll see where we are at that next court date.
Okay, perfect.
All right, make sure you stay in touch with Mr. Ward. He's going to get all the discovery in the case electronically, and then he will, I'm sure, want to get with you and go over all of that before the next court date. All right, you're free to go. Thank
I
you.
would go, 'cause, as far as he did want to amend some bond conditions, I don't know if you guys wanted a formal.
Did you file a
No, I
motion on
didn't. I
that?
just wanted to see if you wanted to do a docket entry or would you like me to file a formal?
I think just to give Ms. Malfino time to see what that is, if y'all want to talk about it real quick before you leave, if there's some agreement, you can let me know. Otherwise, if there's some issue, I'll give her at least a week or so to get ready on that.
I
All right,
completely understand.
just let me know. I'll hold it.
doesn't have to come back.
Yes, sir. I'll hold it, ma'am. And have we seen Mr. Sean Villery, Samuel?